The application, my lord, my lady, is supported by the grounds on the face of the application and the supporting affidavit in support of the application sworn by Geoffrey Ndungu, Willie, the first defendant accused. My lady, from the outset, I want to make it clear that what this application intends to serve is what the constitutional requirements are in Article 49 and Article 50 of the Constitution 2010. And towards that end, my lady, the application is addressing a scenario of having a fair hearing, fair administrative action, and that the accused persons have their day without having to look at the back of their backs to see whether there is somebody else who may be ambushing them. My lady, I have enumerated in the affidavit the reasons why we want my colleague, Ms. Wamaida, recused from this case. And the reason is because of she's conflicted. She's conflicted in the sense that, my lord, my lady, she has had to take instructions from the accused persons at one point. Before the arrest of the second accused person. Yes. Nearly all of them, save for the last accused person. Yes, yes. My lady, at the time the second accused person was being arrested, it was at the behest of Ms. Wamaida, who called him to a place and bought him promised to buy him tea and lunch. And in the midst of that, she took instructions on what the second accused person's defense is, what he knew about this case. She took instructions on what the second accused person's defense is, because at that point, she was trying to know how he participated in this particular offense. So there was disclosure of material privileged information. And on hearing the second accused, that's when she called the police to where they were. And he was arrested. She delivered the second accused person to the police, having taken instructions from him. The same thing happened. The other accused person was called as the third accused person by Wamaida.
Are you representing the car?
Yes, I'm representing the title together with Ms. Morande. Yes, with Ms. Morande. Yes. He was also called, and in the same manner, gave reliable information, gave privileged information to Ms. Wamaida, and he was also arrested. Sent 1,000 shillings as lunch to the second accused. As a thank you that he has now come to her and that they have had a discussion. My lady, that engagement by my colleague, which now becomes unprofessional, persisted after the accused persons were now remanded at the prisons. This one is contained in the affidavit starting paragraph 10 through. Ms. Wamaida, my lord, called the prison welfare number and requested that she wants to speak to the accused persons. At some point, this number was received by the second accused, by the first accused, sorry. Yes, after the independence of this case. Wamaida made a call to the welfare number at prison and requested that she wants to speak to the accused persons. And the person who was on call from the representing the accused persons, who was first called, was the first accused person, Geoffrey. To the accused persons, yes, yes. And the first accused person is the one that she engaged with in that conversation. And a date was set for her to go to prison. Yes, after she, in fact, the first accused told her that we have lawyers and could wish that these advocates be involved in the discussion. The first accused. Yes. So she is the one who told the counsel Wamaida that we are now having advocates. We could wish these advocates to be part of this discussion. But she declined and told them, no, it's not so much about these advocates. Something I want to talk to you people. And her being a person who understands the law, at that point, should have been the first to shake off that particular conversation and desist from getting involved with this accused person. Because she knew now she is representing the family. So following on that particular phone call, Ms. Wamaida proceeded to prisons and called the first accused person, who was brought to her, first accused. They had a conversation with the first accused, sought the first accused information on the offense, and now purportedly wanted to advise the first accused to plead guilty to the offense, that she will help the first accused. This information was also passed to the second, third, and fifth accused persons. Second, third, fourth, and fifth. Second, third, fourth, and fifth accused persons. They were also asked to plead guilty, and fourth and fifth. And fifth, yes. They were promised that if they were to plead guilty to the offense, they will be facilitated. And a figure was mentioned that was to be given through Maida, ranging to 100,000. It is on an affidavit, my lady. Tune of 100,000 shillings. For each. That's the minimum. That's what that was mentioned. That was what was mentioned. I'll give you 100,000, which will be given. Yes. Which will be given and paid. Yes, that was the minimum. And more other promises were given. The question for your leadership to ask is, with this kind of conduct, does it align itself with the calling of Ms. Wamaida to being an advocate of the High Court, who is supposed to advise? The question you have to ask yourself and then answer is this: is this conduct by Ms. Wamaida in line or in tandem with his professional calling, with her professional calling? Getting information about a party she does not act for, who is a party against whom she's acting, is unprofessional. And my lady, that's why we say my colleague is conflicted. She has knowledge of privileged information from these accused persons. Which in the end, my lady, will affect or will interfere with the fairness of this case. My lady, in the case of Waswa versus the Republic, this is petition number 23 of 2019. Yes. Yes, the petition is number 23 of 2019. Ikerad reported 2020. 23 of 2019 into brackets close 2020 KRR at paragraph 77. The court had this to say, my lady. Yes, this Waswa versus the Republic. WA. Yes, that's how it is cited. Waswa. Yes, Waswa versus the Republic. The judge in that case observed that it is a high court. No, Supreme Court, sorry. Supreme Court. Sorry, it's Supreme Court. Yes, 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 yes. The Supreme Court observation.
You have it there because
no, it's a small paragraph. I'm only quoting what concerns the participation of the Board Council, which is 3 lines. Paragraph 77. 77 of that case. Now, the judges of the Supreme Court say victim participation must not be prejudicial to and inconsistent with the rights of accused persons. The court.
So with regard to that,
victim participation through legal counsel must not be prejudicial to and inconsistent with the rights of an accused person. My lady, in section 9 of the Victim Protection Act, 9 of the Victims Protection Act, paragraph 2 of that particular section 9,
you had said you take how many minutes?
I'm finishing.
Okay. But you had said that you take how many minutes?
5.
And you have taken how much?
Around 4.
Paragraph 2.
Yes. It talks of the manner. I don't want to paraphrase because you will read. Let me just say, yes.
I'll say that you rely on section 9.
Yes, yes. Yes, but the catchword under sub Roman 3 of that 2 is that the participation of counsel for the victims should not be inconsistent with a fair and impartial trial. Now, from this conduct, Molo, it is quite clear that Ms. Gomaida has breached her duty as counsel. And she cannot walk. Yes, it's finishing. It's summary. She cannot walk on 2 roads with her 2 legs. My lady, I sat with these accused persons the last time we left court. And I want to tell you, as their advocate representing them, that they are worried that they have a counsel who has been with them and is now feeding the prosecution with information. And their worry is, my Lord, the provisions of the Constitution that requires a fair trial, which is a human right, is and has been breached by my colleague. If I were my colleague, let me tell you, my Lord, I would have escheated this case at the point where that allegation was made. The motivation may be there for her, but our first calling should be her professional calling. So, and I urge you, my Lord, to put this kind of conduct to shame by stopping my colleague from participating in this proceeding. I hear the family has another advocate. They can appoint as many as 10, whatever they want.
As they walk out, and we say that they walk out,
Yes.
and those who are shouting walk out, and I remain there, we don't care. I noted even as you left court last time, you made a lot of noise. Of course, I have not stopped to assist you. Are we in agreement that you remain silent, no matter what your feelings are? You people, all I just said you will explain out. Just tell me, how many want to remain silent from now on? Raise up your hand. So the rest will go to interrupt. Okay, officers who are in court, let me know the emphasize whoever interrupts, just please them out. Those ones who do not commit themselves to this court, to allow their advocates to speak. No matter what you feel, explain yourself. Are we together? Well, I spoke about communication, but you don't understand. Tell me.
Kwa kinasema tuweze kuzingatia maadili ya koti na mali
My Lord, that particular response, I'm finishing. That particular response is contained in paragraph 25 of our supporting affidavit, and it goes to the conduct of Ms. Wamahila. The mobilization she has been doing, which 25 of their supporting affidavit. The mobilization she has been doing, yes. 25 of the supporting affidavit of, yes. So I urge you, my Lord, to maintain the sanctity of this profession by ensuring that our conduct as advocates should be within the parameters that I will lay down. And we stay clear of the lanes that have been properly prescribed, and urge you to uphold our application.